Good afternoon, everybody, and welcome to episode 2 of Stewarts Soundbites. I feel like a television presenter saying that, Gerard. So today we are really lucky because we are joined by Gerard McDermott QC. Gerard doesn't need any introduction, but I'll just quickly say he's one of the country's leading silks who specialises in catastrophic injury cases, and he has really kindly agreed to join us today and speak and to give us his top tips really for experts, I think medical and non-medical, Gerard, who prepare evidence in these types of cases. So I'm not going to drone on because we only have 15 minutes, Gerard, so I'm just going to hand over to you.
Well, thanks, Emma, and thanks for asking me to do this.
Oh, pleasure.
For 10 years or more, I've known that there was room for lawyers to tell experts a little bit more in settings of this kind, or settings of this kind since COVID-19, what we expect from them, and for us to listen what they expect from us. And I think it's vitally important. Although you and I work in the field of catastrophic injury, these lessons are ones that can be used, in my view, across the board. And expert evidence is not just confined, as we think it is, to our sort of field. I mean, we deal with many clinical experts, but in my time just doing personal injury bar work, I've worked with geneticists, I've worked with economists, actuaries, architects, surveyors, financial advisors, marine surveyors, engineers, and many others. And these tips are intended for anyone who may come to give expert evidence before the courts, actually before the courts in other countries, and actually in arbitration and the like. It's really a look at what lawyers expect from expert witnesses. And as I say, it's not just clinical experts. If you want to look at the breadth of expert evidence that's out there, just look at a public inquiry like the Grenfell Tower inquiry, where they have experts in fire safety, in construction, in building materials, and where they've done reconstructions and so on. And that really is worth looking at just to see the breadth of expert evidence that there is and the sort of things it does. If you want to look at the commercial bar or the competition bar, there are expert economists and models and people who do economic models and so on. So I'm not going to try and cover everything in 15 minutes. In fact, I've spent 2 already. And this is really my view, but I hope it's reflected by many. So my first tip, this is my real top tip. You are reporting to the court. You must be and remain independent. You're engaged by one side, but this is not a team game for you. We will want to speak to you, and we may want to look at various parts of your report and ask you to reconsider parts, but it's your report. And if there's one point I would reinforce to every expert, it's your report. And you have to remain independent because that's where your value is. And if you don't, it will show at trial and you'll face criticism. And the witness box, I can tell you, not from experience, but from putting people through their paces in it, is a very lonely place. And you will be there in public giving evidence. And if you haven't approached it in the correct way, you may find yourself in difficulty. And part of the first top tip to remember is, what's your role? It's not to get a particular result. We hope, if we've engaged you and we've worked with you and we have your report, that it will support an outcome that helps our client. But ultimately, you've got to respond to questions that are put to you. You've got to respond to questions that are put in joint statements. And your evidence and the quality of your work will be the better if you have give and take in joint statements and if you listen to points that are put to you. Okay, second tip, be an expert. That sounds a bit obvious, but actually it's a really serious point. Actually, sometimes I see experts that we bring into cases that I do, and we value their expert evidence, but actually what we really want are costings. So for instance, although we routinely instruct a fertility expert in a spinal cord injury case, and I want to know what's involved and what it will cost, It's rare that I would call want to give evidence because it may well be accepted. And that will be, as well as partly a technical issue, partly it's to get the cost of something. But of course, we want expertise in the relevant area. So again, for instance, in orthopedics, when I started at the bar, I suppose we very often just called an orthopedic expert who was expected to cover most areas. But as clinical practice has improved and become more detailed, actually, again, by reference to a spinal cord injury case, I may want an upper limb expert. I want an upper limb expert who deals with the shoulder. When I say deals with the shoulder, I don't want someone who just understands how the various elements of the shoulder mechanism fit together. I want someone who deals with them day in, day out. I want someone who knows about how they will deteriorate with wheelchair use. I want someone actually who will look at the research on it. And they will be an expert because of what they do. They can improve their expertise by keeping up to date so that they can talk about deterioration and so on. And as part of my second tip, be an expert, don't stray outside your area. Of course, in some instances, again, thinking of our own field, we may sometimes ask someone who's covering occupational therapy to give us a view on care, though in most of the cases that you and I do, Emma, that is such a significant element, we will have it dealt with separately. I am very conscious that if you're doing a much lower value claim, you may want to have someone who has more of a generalization, and as long as that's plain and the reason why you've done it, a court will entirely understand that.
Gerard, you just to interrupt you, you mentioned in that section there that some experts will reference research and papers and things. Do you think it's important that those are footnoted and attached, or do you think that's a sort of matter of discretion?
It depends, and it leads me neatly into the next point, which is keep it short. Depends what their role is. In one of our spinal injury cases, Emma, we will always have a central expert who will be the expert in spinal cord injury rehabilitation. They may come from different disciplines initially, but they will have worked and probably still are working in one of the regional spinal injury units, and they'll have expertise across the board. Now, interesting, and in fact, I've had this debate in a specific case recently. Do I want extracts of medical reports and medical notes in those cases? And I have seen one recently where actually, although it's 100 pages long, quite a lot of it is medical notes, but they are relevant. And actually, the expert has very skillfully given the history and taken me through the way, then ultimately will take the court through the way in which this injury has impacted upon the individual by putting in operation notes and review notes and so on. And that's perhaps an exception because in general, although I want to know the notes have been reviewed, and I may want to see a short review of it, I don't want it to cloud what the expert report is about. So again, in another case recently, I saw a psychiatric report, and more than half of it, and the first half of it, consisted of a review of the records. Now, we have a lot of time to digest this. A judge may not. And a judge who may have picked this case up the day before and have 4 or 5 hours to read into it wants to know what issue that expert is dealing with. So sometimes I would suggest it goes in an appendix, and also summary. Summary can very often help. What I think isn't helpful is to see an expert who's picked up a dictating machine and gone through the notes. That's probably not going to be a sufficient summary. And, the cases certainly that we deal with are very high value, and we expect the expert reports to be both extensive and also sometimes quite costly, but that's because people have put time into them. So that's a slightly long-winded reply, and I realize I've got 5 minutes left. So third tip, keep it short as you can. Extracts from the reports, not for everyone. Think about an appendix and always remember the reader, who will ultimately be the judge. Fourth tip, keep up to date. Keep up to date with your clinical practice. More relevant, particularly for those who are recently retired, we need to know that you're current and you're keeping up to date with, if you're a clinician, the clinical improvements there are. You don't need to know the law, but if it's a liability report, for instance, we would expect you to know that the question of foreseeability will often be an issue. If you're a care expert, I'd expect at least a working knowledge of the working time regulations and how it affects shifts. And I'd expect a working knowledge of the minimum wage and things like that. Fourth tip, this is your report, no one else's. If you've used information, that's okay, but make it plain and make sure you understand it. So again, if you're a care expert working for one of the larger, as an associate of one of the larger organizations, they may do research. You need to understand where it's come from. You need to understand how it's been calculated, and you need to understand why you are using that rate. It's important to you, it's important to us, and important to the court. And saying that the office do it is not a good answer. Fifth tip, do the job properly. Well, that sounds a sort of an odd thing to say. I mean it. If it requires a visit to look at a location, then make it. If there are constraints on the information you've had to prepare the report, say so. Check your report and any calculations. They may be challenged. And the paradigm example of that is in a case called Nadaraja, where an expert didn't check his calculations and didn't make a site visit. And at the end of the day, he agreed with me that his report was really not worth relying on. You don't want to be there. Final tip, enjoy it. If you're good and you follow tips 1 to 5, you will. No one wants to do a job they don't enjoy. And I know that whatever field you're working in, you will both have expertise that you want to share, and you'll want to do a good job for the court. You'll want your client to understand that you put forward the things that seem to you to be relevant, that you accepted points that were made against you at the right time, and that you did your job professionally. Now, I realize I've actually got to the end of my notes, and I'm 2 minutes ahead, Emma.
It's very impressive, Gerard. You've done very well. You've been as concise and informative as ever, Gerard. Thank you. Before we wrap up, though, because we do have a couple of minutes, do you have any sort of red flags and sort of cardinal sins? You know, what is the biggest sort of cardinal sin for an expert?
I think one of them is not being prepared. I'll tell you what another cardinal sin is, and it comes back to one of my points. Don't stray outside your expertise. I once did a case for Stewarts, in fact, where a well-known care expert tried to persuade me that there were changes coming in the working time regulations. I knew there weren't. I knew them backwards. And she began to struggle. And actually, it wasn't her job to deal with the working time regulations. And she had not researched it as fully as she could. So, you know, don't take the lawyers on. Again, actually, if you're in a difficult situation and you realize that you have strayed outside your expertise, then say, actually, you're asking me these questions, and I have dealt with it briefly in my report, but that's not really the focus of my report. It's this. And I'm not as up to speed on that as many others would be. You know, it is a lonely place. And, you know, if you get to trial, you can expect, certainly in the bigger cases, very probing cross-examination.
And that's important. I suppose that's important for us as solicitors as well, on the other side of the fence, to know what your expert's limits are and whether you maybe need to think about having somebody else in and being aware. Well,
here's my top tip for a lawyer. Your expert witness is there, and it's their reputation on the line. Don't take them somewhere that they are uncomfortable. If they told you in consultation that they're a bit hesitant about one aspect of the case, don't try and improve it on the hoof.
Yeah.
It's not going to help you. It's certainly not going to help them, and it won't help your case.
Yeah, absolutely. Well, thank you ever so much, Gerard. Really appreciate you coming on and imparting all of your wisdom. I hope everyone's found it useful. Brilliant as always, Gerard. Thank you.
I enjoyed it very much.
Good, good. Well, maybe you'll come back. We see, because we've done these in 15-minute chunks, you know, we don't have enough time for sort of questions. But if anybody does have any questions about on this topic, or anything you'd like to raise on expert evidence, and maybe ask Gerard to look into, then you can email me, and we'll maybe do a follow-up session if we've got some queries. I think
Very happy to.
drag Gerard along.
Me on Twitter, I'll try and help.
Yeah. Okay, so next week, next Wednesday, the 9th at 1 o'clock, we are joined by Chris Smith, who's a senior associate at Stewarts, and we're speaking to the directors at Steps Rehabilitation. They're going to be telling us all about the sort of challenges that they've faced over lockdown and how things are changing for them. And the week after, the 16th, we'll be having a bit of a break from Stewarts Soundbites, because Stewarts are hosting a case management seminar for, funnily enough, the case managers. And they'll be looking at litigation and lockdown, and looking at expert and case management assessments. So tune in for both of those, and thank you very much, everybody. See you soon.
Thank you, Emma.
Bye.